So, how do you do estate planning for retirement? Very carefully. All those things that are saved while you're working for your retirement. You want to make sure that you've got beneficiaries on file because legally that's where the accounts are going to go. And then you want to be careful if you've got the trust as a beneficiary, and then be tax efficient. If you want to give to charity, then by all means give them that money that's going to be taxed the most heavily. And then you will be a legacy maker. You're listening to Legacy Maker Podcast with Kristina Hess. Clear guidance for protecting your wealth, empowering your family, and creating a lasting legacy of generational impact. Legacy Maker, let's go. How do you do estate planning for retirement accounts? This is an area where many people unwittingly and unknowingly make some pretty massive mistakes. So let's talk about this today. All right, Legacy Maker, it's Kristina Hess here with another episode of the Legacy Maker podcast. And today we are talking about how to effectively do estate planning for your retirement accounts. All right, here's my disclaimer. Even though I'm an attorney with over 25 years of experience, I am not your attorney unless you've signed an attorney-client agreement and paid me some money. So this podcast is just for educational advice only. It is not legal advice and hopefully maybe even some entertainment value. All right, so let's dive in. Estate planning for retirement accounts. What do I mean by retirement accounts? Okay. Great question. Retirement accounts mean your IRA, individual retirement account, your 401k. That's an ERISA plan with your employer, your SEP IRA, Roth IRA. There's different types of IRAs. Maybe you work for the government and you have a 403b or other government pensions. These are all retirement accounts. They're accounts that you put assets in while you're working to save money so that when you retire, you can have an income stream, because in the 1970s, the government decided that they were not, and companies were no longer funding large pensions for people, and there was a problem that we needed people to be able to have income in retirement, so the government came up with all of these tax-deferred accounts that you can put money in, get an income tax deduction, and then save up for retirement tax-free. All right, those are all retirement accounts. So how do you do estate planning? And what are some of the mistakes and pitfalls that people make? Well, first of all, you need to understand the 10-year rule. So in 2020, Congress passed the Secure Act, which changed the rules for retirement. What does this mean? Legally, a retirement account is going to pass to who you designate as a beneficiary on file with the custodian. If your IRA is at Schwab or Fidelity or T. Rowe Price or wherever the account is held, you're going to make a beneficiary designation. Or if you have a private profit sharing plan or defined benefit plan, it's going to be with your plan documents who's listed as the beneficiaries on file. Legally, that's where the account goes. So that's mistake number one. People unknowingly think, oh, well, I set up a will, I have a trust, I've got the 5 legal documents that everybody needs, a trust, a will, power of attorney, healthcare, HIPAA. I'm covered, right? My trust is going to say what happens to my IRA. No. Who you list as a beneficiary on file with the IRA, that's where your IRA goes. So what happens? It'll be spouse. What happens if you get divorced? You have to make sure you update your beneficiaries. So problem number one is failing to update beneficiaries when your life changes. Maybe someone passed away. So a lot of times, spouses with no children will have each other 100% primary beneficiary, which is great. You want your spouse to be 100% primary beneficiary. But then when they've lived together for 50 some plus years, one of them dies, chances are the other one's going to die pretty soon thereafter. If they don't have a contingent beneficiary, the retirement account is going to go to probate. So you need to have, that's another problem. You need to have a couple of layers of beneficiaries. Problem number 2. Problem number 3 is you don't want minor beneficiaries. Minors cannot inherit property. What's a minor? It depends by the state that you live in, but typically a minor is someone under the age of 18 years of age or whatever the age of majority is in your state. So I'll give you an example. We had a case where the father put his son and his grandson 50-50 beneficiaries on all of his life insurance and retirement accounts, which in theory is great. He wanted to give half to his son, half to his grandson, but when the grandfather passed away, his grandson was 12. A 12-year-old cannot inherit property. So that account had to go to probate to have a guardianship estate established for the grandson because he's a minor. So that was not a good outcome. The fourth thing is with the Secure Act, which passed in 2020, it changed the rules as to what happens with the retirement account. Retirement accounts, if they're tax deferred, you put money in while you're working and you get an income tax deduction. And then they grow tax free until you retire, or so you can start taking withdrawals at either 59 and a half, or when you're 73 is the latest time you have to start taking withdrawals. So at some point when you retire, you're going to start taking distributions, and then that distribution is subject to income tax. If you die, if your beneficiary doesn't know that all these accounts are tax deferred and they're filling out the beneficiary form, and one of the options is take a lump sum, and if they check, oh yeah, hey, I just inherited $500,000 from my mom, I'll check the box lump sum. They get $500,000. They think they're sitting pretty. Fast forward to learn that all of that $500,000 is subject to income tax, and they took the whole thing in the first year. So they're going to lose anywhere from 30 to 50% to income taxes depending upon where they live. So they'll be in a high tax bracket for federal. If they're state, if they live in like New York or California, where we have very high income tax, they're going to lose up to 50% in income tax. If they live in a state like Texas or Florida, where there's no state income tax, they're going to be sitting a little prettier, but they're still probably going to be in the 37 to 39% federal tax bracket. So they're still going to lose a massive amount of that $500,000. So what's the better option? The better option is you want to be able to stretch it. Now, when my father passed away many years ago, we inherited his IRA, me and my two siblings. We could stretch his IRA over our life expectancy. So we could take a minimum distribution each year and the account could continue to grow tax-free for life. That was amazing. They changed that rule. That rule's gone. So now, after 2020, we have the Secure Act. The Secure Act says non-spousal beneficiaries. So that's why I said you usually want your spouse to be 100% primary beneficiary, because the spouse can do what's called a spousal rollover on the IRA. They can roll it over into their own retirement account, and then they can continue to take a minimum distribution for the rest of their life. Much better tax outcome. But the rest of us, children, grandchildren, any beneficiary that is not a special needs beneficiary, chronically ill or disabled, or within 10 years in age to the retiree who passed away, you have 10 years to take all of the account out. That's what the Secure Act did. So after the Secure Act, the rest of us have 10 years. So if your parent died in this hypothetical and you inherited $500,000 in an IRA, you have to take a minimum distribution within 1 year, the following year of the death, and then you have to continue to take distributions, and then by year 10, you have to liquidate the entire account. And every time you take a distribution out, you're going to be paying income tax on that distribution. So the Secure Act changed the rules, but you don't want to do a lump sum. You want to do the 10-year stretch if possible, unless the account is very small and the income tax to you will be negligible. So what's another mistake that people make? Now, they might say, oh, I did my estate plan, I did my trust, my will, I did the 5 legal documents that everybody needs, trust, will, power of attorney, advanced healthcare directive, HIPAA. I've got it all down, but maybe the attorney didn't tell them what to do with the retirement accounts. I've had people come to me and they put the trust as the beneficiary on the retirement account, which in theory isn't bad, but it depends on how the trust is set up. So a lot of financial advisors will tell their clients, don't put the trust as a beneficiary on your retirement account. Now the answer is, it depends. It could be a good thing. maybe you have a lot of charitable beneficiaries or other beneficiaries, and you want to update your trust periodically, and you don't want to have to go to your 5 retirement account custodians and constantly be updating the retirement account. So it makes sense to have the trust as a beneficiary. But you want to make sure, this is very important, you want to make sure that if the trust is the beneficiary on your retirement account, the trust has to have what we call conduit trust provisions or see-through trust provisions. What this means is the trust has special language that says if a retirement account comes in, then this trust will qualify as a designated beneficiary under the tax code so that you can get the mandatory 10-year stretch. Or if you had a special needs beneficiary, you could get the lifetime stretch for that special needs beneficiary. So very important. We've had people come to us over the years who had the trust 100% beneficiary on their account. All of their wealth, like $1 million, is in their retirement account. And then I look at the trust, and the trust has no retirement clauses. So what would happen in that situation? Had that person died and the trust doesn't have the see-through language, it doesn't qualify as a designated beneficiary. It's either going to be an immediate payout, mandatory, and then that huge tax bill, or a 5-year payout if it qualifies as an estate. So very bad tax outcome for the family. So make sure if you need the trust to be the beneficiary, because maybe you have minors who are beneficiaries, you want your grandkids or your kids are minors. Remember, minors can't inherit property directly. So if you want them to receive the retirement account, make sure the trust is the beneficiary for them, but also make sure the trust has the correct language. Very important. All right. So the last thing that you'll want to do for estate planning for a retirement account. So just to recap a couple of things we talked about. If you're married, then most likely you want your spouse to be 100% primary beneficiary. If your children are adults or your other beneficiaries are charities, which we'll talk about in a second, or other individuals who are adults, then they can be listed directly as beneficiaries on file with the account custodian, and they could receive the retirement directly. So you may want to use a trust when you want to update your beneficiaries frequently. You want the assets to go to charity and you want to change those charities. You want to do a charitable remainder trust because you want to give your kids the ability to stretch the IRA for their lifetime and have the remainder go to charity. If you have very large retirement accounts, this could be a good option. So there's a lot of times when it might make sense to have the trust as a beneficiary on your retirement account, but you really need to make sure that you discuss that with your attorney and make sure your trust is drafted correctly. The last thing is for clients that want to do charitable giving, a lot of times what I'll see is they'll have 10% of their trust going to charity, which is great. You know, they're creating a charitable legacy. They're doing all of that. They're going to feel good, build their legacy, have charitable impact. It's a wonderful thing. However, it would be more tax efficient to give the charity from the retirement account because the charities don't pay income tax. Now, if you have a Roth IRA, of course, there's no income tax. You're still subject to the 10-year rule, however. But for the charities, if you want to give 10% of your estate to charity, or you want to give some portion of your estate, maybe, 50% or whatever it is, whatever percentage of your estate to charity, it's most tax efficient to have it come from assets that would be subject to income tax, which under the code is called income in respect of a decedent, IRD. You want all of those accounts to go to charity because the charities aren't going to pay that 30 to 50% income tax. So you can leave an amazing legacy, give the charities the money, and bypass the tax altogether. So how do you do estate planning for retirement? Very carefully. So just to recap some of the things we talked about, retirement accounts include all those tax-deferred accounts, annuities that maybe had tax-deferred money, IRA, SEP IRA, Roth IRA, 403B, 401k, pensions, all those things that are saved while you're working for your retirement. You want to make sure that you've got beneficiaries on file because legally that's where the accounts are going to go. And then you want to be careful if you've got the trust as a beneficiary, and then be tax efficient If you want to give to charity, then by all means give them that money that's going to be taxed the most heavily. And then you will be a legacy maker. So thanks for joining us today. It's been my pleasure, Kristina Hess, the Legacy Maker podcast, to talk to you today about how to efficiently and effectively do estate planning for your retirement accounts. Until next time, be a legacy maker. Thanks for joining me today. When you're ready to take the next step, connect with us at legacymakerpodcast.com. And until next time, stay wise, stay intentional, stay a legacy maker.